Good afternoon, everybody. My name is Chris Justice. I'm an employment lawyer at Samfiru, Tumarkin. I work out of the Toronto, Ontario offices. And as always, I'm here today to hopefully answer as many questions regarding employment situations as I can. So if you've got a question with respect to a job you have, or maybe you've been let go and given a severance offer, or maybe you have some questions about something before entering an employment relationship or a work situation, as I say, get your questions in and I'll answer as many as I can today. Before getting into the questions, though, as I always do as well, I like to start off with a few topics, just some things that have either come across my desk as of late or some stuff that's going on in the news. This time around, I noticed that there are some news stories that have actually happened before, but more news coming out regarding the purchase and sale of businesses. And so a lot of questions will center around if you're an employee and the business that you're working for is sold, what does that mean as far as your employment? What options do you have? What sort of scenarios can come up? So it's like I say, something that's often coming out in the news, something that I'm sure will continue on going forward. So if you are in a situation like this, you definitely want to listen in. And again, if you have any questions, send them in. But if you are someone in this position, you're at a company that's being sold and the purchaser wants to have you continue working for them, such that there's no break in your employment whatsoever, then it is very possible for somebody to work with one company, have it get sold, and then just seamlessly transition into working for the next company. And usually when that happens, all the seniority that employee had with the previous company will be kept intact, so that if that employee is ever let go later on by the purchaser of the business, they're not going to be considered a fresh employee on the day that they actually started with that second company. That said, before you start work with another company, maybe a company that's buying out your business or the company that you work for, you want to be wary and cautious around a new contract being put in front of you to sign. A lot of times the purchaser of the business, the new company that's coming in, they're going to want to have the employees that stay on board sign new employment agreements. And in those employment agreements, there can actually be language that will deal with seniority and whether they actually take into consideration your full seniority with the previous company to one degree or another. And that's just one example of something that you should be on the lookout for, because you don't want to be signing a new agreement with this company that's bought out the business only to find out later on that you've signed something that's going to have a big change or a big impact, I should say, on your entitlements. Maybe there was no contract with the first company, and so that could very well be in a lot of cases to your benefit. But by being asked to sign a new contract or an updated contract, a lot of times that is going to be for the company's benefit, not yours. And all the more reason why you got to be cautious when you're in that sort of situation, signing a contract, at least before getting legal advice. Now, if you work for a company and they get bought out by somebody else and you are not hired on with the new company, then you've essentially been terminated by the seller of the business, and you would be able to go after them for your full severance. And then there's other situations where maybe you are being asked to join the new company, and there's some term in a contract that they're asking you to sign that's way different than what you were used to. There's also the potential that you could turn down an offer like that, as long as you can show that whatever the term is or whatever the conditions are, they're significantly different than what you had with your first company. So suffice to say, if you're in the situation, definitely before joining another company or potentially leaving a company in that scenario, you want to give us a call. You want to get some legal advice, just so that at the very least you know what your options are in these situations and whether or not you may be entitled to your full severance, depending on what action or decision you make. So that was one thing I wanted to talk about off the top. There's another thing I wanted to talk about that came up in the news recently, and that had to do with an employee who had videotaped or filmed, recorded the termination meeting. and then posted that recording or that video online on social media. I think it was TikTok. And I think with social media, with the advent of the internet and just how easily information can spread, a lot of people I find are posting things to social media, whether it's a recording of their termination meeting, but it could be anything really. And their employers then finding out about these things that are being posted and potentially taking action against that person. Now, if you've been let go and you're taking a recording of a termination meeting, you may not, of course, be terminated a second time, but there could be a breach of confidentiality in the information that you're sort of distributing online. And there could be other consequences in doing that. So before deciding to put any recording, whether it's video or audio, for example, up on social media, whether you've been let go from your employer or you're still actively working there, you definitely want to pause for a second and try to understand the consequences of that. And again, getting some legal advice, if anything, before doing that. Because a lot of people these days find, or I find actually, that a lot of people don't think about necessarily what they're posting or what they're doing. Maybe they don't even think that their employer is going to find out about what they're posting or doing, which is completely possible. But then there's another situation where they do find out, where maybe someone tells them of something that was posted on Instagram or TikTok or Facebook. And then the employer can very easily terminate that employee if they don't approve of that messaging or what's being done. Now, that's not to say that you're not owed severance. And I think a lot of employers are in the wrong when they terminate people for cause and don't pay them anything just because something may have been posted, although it will depend on what you're posting exactly. But you can still lose your job. That's just the practical reality that is possible. And your employer will have to pay severance, like I say, but nonetheless, there are some consequences. So yeah, if you're somebody who's maybe done this or maybe have had discussions with their employer about posting something online and you want some guidance on sort of how best to communicate with your employer, what to do in those sorts of situations, then again, definitely give us a shout, because the last thing you want to do is do something that you weren't even considering was going to be found out, only to have that result in an outcome that you ultimately don't want or desire. But those are a couple situations that sort of I saw in the news. There was another situation that came across my desk. And this situation actually involved an employee who was being let go for alleged cause. Now, I mentioned just a second ago that anytime an employer says that they have cause to terminate your employment, whatever the stated reason is, the vast majority of cases, employers actually don't have cause to terminate your employment. And I think a lot of people, even when just being told that they're being let go for cause, that they engaged in some kind of misconduct, a lot of people assume that they're therefore not entitled to something, or maybe they're entitled to much less, especially long service employees. And it's a shame, because had they got some legal advice, they would have likely been told by a lawyer that the employer, the company, actually doesn't have cause to dismiss you. Even if you engaged in some misconduct, like this client of mine the other day engaged in some misconduct, it doesn't necessarily mean, again, that there's cause and that you're owed nothing on your way out. There's got to be something very, very serious that's gone on. There's got to be maybe a history of you lying to your employer all the time, several warnings being given to you, and simply no improvement after that. So employers have to go through typically a lot before they can just go to a termination for cause. And far too often, I think they jump the gun and try and pull that trigger sooner than they should. And then they, on the back end, end up getting hit with potential action against them for severance, not to mention for potential further damages, just based on a lot of times what's sort of a meritless cause allegation. There's no real basis or founding to it. So like I say, I had this client come across my desk the other day who had been let go for alleged cause. And, lo and behold, I found out that the company didn't do any investigation into the allegations. The company didn't give this person any second chances. There was a completely spotless disciplinary record beforehand. And this person had been at the company for 20 years. So when you think of it, it was a situation where the punishment didn't fit the crime, so to speak. And again, that's where I think a lot of employers go do it wrong. they sort of do something that's disproportionate to the situation. Again, not to say that there aren't cases where cause is valid, but they're much more far and few between, given how many times as a lawyer I see these things on a daily basis. But having said that, I'm just going to get into some of the questions, and then if I need to, I can go back to some of the stuff that I've seen in the news or some experiences that I've been having in the workplace as of late. But I've got one question in from MK, who's saying that they're returning from a construction job after a mat leave. They reached out to their employer to confirm the return, as well as the role that they were going to go back to. And they were told that they'd be returning to the same team and position. Okay, so far so good. But now there's been a change, and they've actually been given a completely different job with different shifts. And the question is whether or not their employer can do this, because this individual, MK, thinks that they're punishing them for taking that leave. And unfortunately, this happens a lot, far too often, where somebody goes on a maternity leave, or it could be a disability leave. There could be a whole number of leaves of absences that people go on. And, rightfully so, they're expecting upon the return to be given their old job back, same duties, same hours, which is generally the legal obligation that their employer will have. But a lot of times, and as it seems like in MK's case, you come back to something that's different. Maybe you're told that we don't have your job at the company anymore. It's not a position that's available anymore. Perhaps they had filled the position while you were gone. But nonetheless, you're told that your position isn't there, and you've got to accept something that's a lot different than what you had signed up to do to begin with. And so basically, if it weren't for going off on that maternity leave, or it weren't for going off on a disability leave, the idea is that this wouldn't have happened. You would have continued working in that role, working on those shifts, and there wouldn't have been a change. And it was only because the leave had to happen that this change happened. Well, if that's true, and you can make that out, and you've got the evidence to show that, then you have a solid case, not only for your full severance, because they've breached the terms of your employment and switched it up on you significantly, but also you have a case for human rights damages based on, again, the fact that the maternity leave, or whatever leave we're talking about, is at least part of the reason why, if not entirely, but at least part of the reason why your employer did what they did. So if you're in a situation like this, you definitely don't want to be coming back to a different job and accepting it. You don't want to be telling your employer that you're ultimately agreeable to that position, because that's going to be held against you later on. It's going to be difficult for you then to change your mind after that point. So you definitely want to be sure, again, that you're communicating with your employer in the correct way, and that you're not saying anything that might come back to haunt you later on. And again, more reason why getting legal advice and sort of having an employment lawyer guide you through that process is going to be most ideal. I've got another question in from Luke, who said that they were fired recently from a small business after 4 years. Last week, they were let go, and after looking at the record of employment, they noticed that the reason for the dismissal was code M, for dismissal/suspension. But the employer, I think, apparently told staff that it was due to a lack of work. And so the question is that if the person, if Luke in this case was let go due to a lack of hours and work, why isn't that what was put on the record of employment, and therefore make it easier to collect EI? And that's a good question, because normally if you've been let go and on your record of employment, it says, or it has code M as the reason for dismissal, normally that's reserved for situations where the employer is alleging that they have cause to terminate your employment. Going back to what I said a minute ago, as far as, situations where people may be deceitful or dishonest to their employer, or there might be an egregious situation, maybe involving sexual harassment or something, as I say, that's egregious, that could amount to cause. Normally that code on the record of employment is reserved for those cases, the so-called worst offenders. But otherwise, the record of employment often will actually say that the reason for dismissal was due to a shortage of work or a lack of work. And that has its own letter, which is code A, And that's what's typically noted down in the record of employment. And again, Luke has stated that there's an issue collecting EI when there's a code M on someone's record of employment versus if it were to say lack of work. And that's again because a lack of work is a without cause dismissal. It's essentially through no fault of your own. It's not as a result of some serious misconduct that you've engaged in. And so you'll get your EI typically. But when Service Canada looks at code M, they can sometimes and oftentimes assume that there's some more serious allegation going on. And then that ends up getting your EI either declined altogether or potentially delayed to some degree, which can just put more further stress and strain on you yourself. So that is a huge issue, especially if the employer is saying that it was due to a lack of work. Then they need to be consistent with what they're saying and what they're reporting to the government on the record of employment. And if there's some suggestion of bad faith here, if the employer themselves is being dishonest in some regard, or doing something in bad faith just so that the individual maybe suffers on the back end, then that's also another scenario where you're going to get into employers potentially being on the hook for punitive damages, for extra damages based on the way in which they terminated your employment and the surrounding facts about that. But it's an important question, and again, something that happens far too often, Luke. So thank you for your question. I have another question in from Rick. Rick is stating or saying that they've signed a non-competition clause because they were told that if they did not, I assume they would be fired. And Rick is asking whether or not the non-compete is enforceable. And actually, Rick, if you are in Ontario, as of, I believe it was late 2021, the province placed a ban on non-competition clauses, partly or primarily for the reason that they prevent somebody from going out and essentially earning a living after they've been let go. Before the ban was put in effect in Ontario, there was a long line of case law and legal history about how non-competition clauses were frowned upon. So it was no surprise that, a ban eventually came down the pipeline. But the reason why they were frowned upon before the ban came into effect is the same reason, as I say, because if you've been let go, a lot of times through no fault of your own, and now you're being forced to go and look for another job, to have something say you can't work for any competitors of ours, because there's a lot of industries where there's a lot of competition, of course, and that's going to limit a lot of your opportunities. That's why judges in the past have historically sort of frowned upon these clauses. And it's been the job of the employer to sort of try and prove that these clauses were reasonable. And then you get into the minutia about what that specific non-competition clause says. But if someone has signed a non-competition clause after 2021, even if the intention is to sort of prevent them from looking for work to some degree after they're done, it's not going to be enforced by a court. Given the ban. So even if, again, it's signed, it's essentially not going to be worth the paper that it's signed on. Now, there may be some aspects of a non-compete that aren't truly a non-competition clause in their essence. There's sometimes non-solicitation clauses that can be included in a non-compete clause. And so it's possible that aspects of it could be enforced, because usually non-solicitation clauses deal with somebody who's left a company, sort of taking employees and staff away from that company and having them join a new company of theirs. So that's still potentially enforceable. But as far as your standard sort of run-of-the-mill non-compete clause that says you can't work for any competitors of ours for a year or two after you leave this position, the employer's not going to be able to rely on that. But otherwise, Rick, you may want to give us a shout if there's some more context or detail to your case, and we can definitely kind of talk it through with you during a consultation, and at least give you sort of an idea of what may come. Not to mention, Rick, as well, that if somebody is put under duress or pressured to sign something, and this just applies in general, not just to non-competes, but if there's duress or pressure put on someone to sign something, there is another argument that could be made there to say that, as I say, duress or pressure was put on that individual, and that it wasn't something that was signed freely and voluntarily, like they didn't have time to consider it, for instance, or maybe get some legal advice. And again, this is a point that more so relates to just generally speaking, contractual issues. And, there are definitely times where employers will tell somebody, here's a piece of paper, sign it before you leave this room. Or before 5 o'clock, I want to see this signed on my desk. And you literally have no time to even consider it yourself, let alone get legal advice. And as I say, that can be an issue for companies. So they're going to want to have, that sort of thing touched on and dealt with. And I'm just getting a follow-up from Rick saying it was before 2021. It was before 2021 that he signed a non-compete. Now the jury's out, so to speak, somewhat on whether the ban that happened in 2021 is retroactive and whether it applies to situations where you've signed something before the ban took effect in Ontario. But you just go back to, at the very least, how the rules were before the ban was put in place. And that's by really analyzing the non-competition clause itself. So before the ban was put into place, and even now, I'm sure the focal point is going to be on, number one, how long is the ban? How long is the non-compete in place for? Is it for 3 months or is it for 2 years? The greater the time, normally the less likely it's going to be enforced. So that's one factor. Another issue or another factor that the courts will look at when it comes to non-competes has to do with the geographical scope of the ban. So you'll see non-competes sometimes say that for 3 months after you're let go, you can't work for any of our competitors within a 5-kilometer radius of head office. And then there's other non-competes that are going to say you can't work for any competitors globally for 2 years after you're let go or after you're done with the company. So the geographic scope is another factor. And again, normally the wider the scope, less likely that a court is going to think it's reasonable. And then there's another factor on non-competes as far as the nature of the ban or the non-compete clause itself. So, for example, you could have a situation where it says you can't work for any of our competitors in any position whatsoever for 2 years. And then there's another form of a non-compete that might say you can't work for any of our competitors in the capacity as a salesperson or a director or something like that, and actually make the position that we're talking about a bit more confined. And again, same thing, the broader it is, if it doesn't mention any specific roles or duties or services being given, then less likely it's going to be enforced. So those are some of the main factors the courts look at as far as whether a non-compete even has a chance to be enforced. Because the presumption is that it's unenforceable and the employer is the one who has to prove it's enforceable. So they've got to really go through a lot of work to show that. A lot of times they don't even bother to show that, to be honest with you. They just let it lie. They don't bother with it, even if you've signed something. But they do have an uphill battle to climb. And as I say, some of those are the main factors courts will look at. So it's not something where it's going to be a black and white answer. But at least you can get a good idea, again, if you speak to one of our lawyers at the firm, on where the risk lies and perhaps roughly what the risk is on you or the risk is on them, conversely. But thanks, Rick, for the question. It's good. A lot of questions do come in around non-competes. So that was a good one, because again, we still don't know yet on the retroactive application. This is an area of case law that's going to be further fleshed out as we go forward now from the ban. But I'm sure that at the very least, the courts are going to use the same sort of lens or analysis that they did before. And that's where I think it's going to be tough for the employer to enforce it. I've got another question in from David on Facebook, who's saying that their wife was hired 1 year ago as a permanent full-time employee. And at that time, she, the wife of his, signed a contract that says she's to work from home 5 days a week. Now she's being told that they want people to come back into the office, saying that it'll start at once a week and then ramp up after that. The nearest office to this individual is 120 kilometers from their home. Can they force her into the office? And again, this is a good question. It came up a lot when the pandemic started and sort of time passed. A lot of people were working from home, but they didn't necessarily have a contract saying that this was a work from home position. And a lot of times employers eventually started calling these people back. And because they didn't have a contract that said it was a work from home role, even though they may have worked temporarily from home for, let's say, a year or two, employers had and do have a lot more leverage in a situation like that. And then the employee's not necessarily going to be able to sort of dig in and demand that they continue working from home. However, in David's wife's situation, there was a contract signed that specifically says that it's a work from home position 5 days a week. So that is a term of her contract. It's reasonable, more reasonable for her to expect that that's not going to be breached. It wasn't as though she worked, on site prior to that. It's always, from the sounds of it, been a work from home role. And so if the employer is coming to her and saying, we want people coming into the office, which may be only starting out as a day a week, but ramping up to potentially 5 days, that's going to constitute a significant change to the terms that David's wife agreed to. And so in that situation, actually, his wife is going to have more leverage to dig in and say, hold up a minute, I don't agree to this change. This is what I signed up to do, ABC. You're now changing it. Now it's DEF. And I'm not agreeable to that. This is considered a big change to the terms of my employment. So that's number one that I often recommend people do if they've got a situation like that, where there's a very clear term of their employment to do work from home, or maybe it's to earn a certain wage or work a certain number of hours a week. Doesn't really matter. If you've got something solidified in that sense and your employer's coming now and saying, we're going to change it, even if it's a change that's not, you're not being targeted at, and it's more of a good faith change, it still is a big change. And you still have the option to either accept it, but then you risk not being able to go back. And now you may be no longer working from home, or whatever the change is, you're going to be now assessed at that. Or you can dig in, as I say, and say that you're not agreeable to that. Now, if you say that and you push back and you object to the change, then your employer is going to have a decision to make, which is either to give you what you want, which may be an ideal scenario, or tell you that despite your objection, it is what it is. It's, I guess, our way or the highway, and you're going to have to accept it. Now, if that happens, at least you have evidence that you pushed back, that you objected. You have evidence that you gave your employer at least one opportunity to revert back to how things were. And if they're still insisting that it's their way or the highway, then you're going to have a much more solid case to show that there's a breach, that it's absolutely certain there would have been a breach had you continued working there, given that information, given that evidence, and that you can then essentially go after that employer for your full severance as though you'd been let go. Now, David's wife has also got a situation where the nearest office to them is 120 kilometers from their home. And that's another consideration. If someone is asking you to come into the office and you've never come into the office, and that the office would take you, an hour or two to get there from your home, now not only is your employer demanding that you work from a physical office, which was not a part of your employment before, but they're now trying to enforce the obligation of you having to commute there and back, which could add 1, 2, 3, 4 hours to your day for all I know, which is also another change that you didn't have in your contract before, and probably partly the reason why a work from home situation was beneficial to begin with. So if even if it was just changing the requirement to have you come in, that alone would seem to me like it's a big enough change to assert your rights and to claim your full severance if they're not going to go back to how things were. But when you factor in this commute and this added mileage, that just doubly so makes it a clear material change to the terms of that person's employment. And in law, that's known as a constructive dismissal, when there's been a significant change to the terms of someone's employment that they do not consent to. So you don't want to be agreeing to something, even if you think it's temporarily. You want to get legal advice so you can communicate the proper thing to your employer, because in David's wife's situation, this person could very easily be entitled to 3, 4, 5, 6 months of severance, even though they were only at the company for a year, by virtue of the breaches of the terms of their employment, based on the situation. But thanks, David, for that question. It's, again, another situation that I find a lot of people are in these days. And that actually does it for me today as far as my time. I thank everyone for your questions. If I didn't answer your question, I apologize. Do, though, connect with us. There's going to be more Q&As going on, more sessions relating to employment law, as you see down below there, with Mr. Samfiru himself this Wednesday. So anyone who didn't have their questions answered, tune in that day Lior will definitely answer your questions. Thanks again for everyone's time, and I'm sure I'll see you all soon enough. But do take care. Bye for now.